All right, so I think we can get started. So I'm going to first just have you guys introduce yourself. So for everyone here, the topic of today is we're going to look at the legal ground of electronic signatures and in relation to the real estate industry. And as I think we all know, there's a bit of a debate on are electronic signatures valid? A lot of people have started doing them more and more. I myself, I'm one of them. And a lot of us haven't considered the fact that we need to maybe just check in if this is something that can, hold up in court. And if it can't, what are the steps that we need to take? So first, we're going to learn a little bit about the law, learn about maybe a case or two, and take it from there. So I think just to get started, David, if you would please just maybe introduce yourself to the audience.
Yeah, perfect. Well, firstly, let me start by saying thanks for hosting this, and to Courtney and Janet, thanks for organizing. So my name's David Campbell. I'm a director at Newman White Attorneys, which is a leading property law firm in KZN. I'm an admitted attorney, notary, and conveyancer. So I specialize in conveyancing, developments, and general property-related matters. So we look at not only, receiving a sale agreement, doing the transfer, but we also look at when things go wrong, which is what we can go into with regards to today's talk. So yeah, that's just my background. And again, thanks for having me.
Thank you so much. And then Jan, I'm sure the audience are familiar with you and also with Courtney, but I think we still need to do our proper introduction. So Jan, I'm going to start with you.
Hi, everybody. Thank you so much for being here. My name is Janet Alexander, as you may know, and I'm with PropAcademy, and we're quite excited to bring you this topic. It's quite a difficult one to wrap your brain around, and there's a lot of legalities that Dave is going to explain to us in the Electronics Act and highlight those. Yeah, that's it from me.
Thanks, Jan. And Courtney, just quickly on your side as well.
Hi, everybody. I'm Courtney from PropAcademy. I know a lot of the people in the chat room, so I'm so happy that you joined us. If you've missed and you've just joined now, PropAcademy is an online training provider for the real estate sector. And please get your notepads out, because this is going to be very interesting. I'm very excited to hear what David has to say.
Absolutely. All right, so I think let's get started. So David, as we discussed and prepared, the first area we're going to discuss, or that you're going to enlighten us with, is looking at the legal requirements for a valid sale agreement. So the first question we can perhaps look at, or the first topic, is what makes a property sale agreement officially valid according to the law? And does the law treat all types of property the same when it comes to selling them? So maybe we can unpack this first.
Okay, perfect. So with regards to the first part of the question, when you're looking at the legal requirements for a valid sale agreement, your starting point is going to be the Alienation of Land Act, which is 68 of 1981. So the Alienation of Land Act prescribes certain formalities which have to be complied with in order for a contract of sale in relation to immovable property to be valid. In terms of that act, there's actually only two requirements, and this is something not a lot of people realize, is that for the contract of sale for immovable property, the only two legal requirements is that it needs to be contained in a deed of alienation. So that is your traditional sale agreement. So, you've got a piece of paper, it's got a property description on it, it's got the parties, and it's got a purchase price and how it's to be paid. So that's your founding document, and that's the first document that's required, your deed of alienation. Moving on from that, the second requirement is that the deed of alienation or sale agreement needs to be signed by both of the parties thereto, or all of the parties thereto, or it can be signed on their behalf by their agents who are acting on a written authority. So, any agent will know you're often dealing with a third party who has a power of attorney. So that person is an agent acting on behalf of another person, and they have the legal standing to sign a sale agreement. But that is obviously where today's discussion stems from. The second requirement, which is it needs to be signed by both of the parties, or all of the parties there too. The second part of that question is where it gets a bit more interesting, I would say, because, when we're thinking about a contract of sale or sale agreement for a movable property, traditionally we are thinking of, okay, you've got a residential property, a sectional title property, and one party is selling it to another. And that is correct, but it goes beyond that, because What you're also looking at is what about sale of shares in a property owning entity? So that's where you also have to comply with the Alienation of Land Act, because even though you might be selling you can't form a new CC now, but traditionally a lot of people have liked to own property in a closed corporation. And instead of now selling the property out of the closed corporation, so that's a situation where the parties to the contract would be the closed corporation as the owner of the property and the purchaser buying the property from the closed corporation. What you could be looking at is the purchaser buying the shares or members' interest in the closed corporation that then owns the underlying property. Now, that is also a contract of sale as defined in the Alienation of Land Act. So if you're dealing with the sale of shares in a property owning entity, you still have to go back to look at, okay, what are the legal requirements? So it still needs to be contained in a deed of alienation, and it still needs to be signed by both of the parties or all of the parties there too.
All right. And I've heard something about the changes in paying taxes when buying property shares. Can you maybe explain what's new there?
Yeah, so it's actually quite interesting because it's not a new topic, and it's the same with the electronic signatures. It's not, this new topic. It's just something that's getting more sort of information put out there and more people becoming aware of it. So traditionally, when you were buying shares in a property owning company, there was no transfer duty that attached to that transfer. So that was why it was a very popular option to utilize. So I own a property in a CC. Instead of selling the property out of the CC and my purchaser paying transfer duty on the value of the property, here all I was doing is I was transferring the member's interest. It's not a transaction that goes to the deeds office. And so traditionally, it wasn't then attracting transfer duty on the fair market value of the property. That situation has changed. I mean, it actually changed in 2002, to be honest. And what it now states is that where it's a residential property that's owned by the company, transfer duty does actually get attracted onto the fair market value of the shares. So it's not the property value of the property, although if it's a CC that's only owning one residential property, it's one and the same thing. But obviously, so if you have a CC where its asset base comprises 50% or more of residential property and you're selling the shares in that, then it's going to attract transfer duty on the value of the shares. So it was closing a loophole. A lot of people were just using it, transferring residential property, owning it in a company, transferring to a purchaser, and thereby not attracting transfer duty. Whereas now they're saying if it's residential property, you don't have that benefit anymore. You are now going to pay transfer duty as if it is a standard transfer.
All right, that makes sense. Okay, so next we can maybe look at how a sale agreement is signed, and maybe we could explore why are more people using electronic signatures for property deals these days. Obviously, it has a lot to do with the new digital age, but it is coming up more and more. What is your take on that?
Okay, so I think we just need to look at the people who are sitting in on this meeting to see why it would be increasingly common to utilize electronic signatures. I mean, we have people sitting all over South Africa and we may as well be in the same room. So, again, traditionally you as an estate agent or property practitioner would be having a sit down with your purchaser and seller. You would be producing a written word document and the parties would sit and sign it with you, and that would be your sale agreement. So just a quick term that is good to define at the outset of this when we're looking at signatures. When I look at electronic signatures, I find it better to define it as in contrast to what it isn't. And what it isn't is your traditional wet ink signature. A wet ink signature is where I've got a pen in hand and I am signing with wet ink. If it's not that, then we're looking at electronic signatures, which then take many forms and we can touch on. But again, so we are now in an age where people are traveling. People have access to technology. It's a fast-paced environment that we're working in. So we have a situation where our seller is sitting in Joburg. He's about to get on a plane to go overseas. The property is in Durban. The agent and the purchaser are in Durban. The purchase is signed, and there's a period of time for the seller to accept the offer. Now, what you would traditionally expect is, okay, so you're going to email this contract, you're going to scan it. Once it's signed by the purchaser, you're going to email it and send it to your seller. Your seller is then expected on the other end to find a printer, to print it, to then countersign, initial the document, sign when it needs to be signed, and then scan it and send it back. And only once all of that has happened do you actually have a valid sale agreement. So you can see why there's this increasing need for people to say, well, okay, you get it signed, you're going to send it to me. I've got the technology here to attach a signature to this without having to get a printer, without having to then find a scanner to send it back. And I find quite often, to be honest, is that it's not the printer that's the problem, it's the scanner. You know, it's just, that's sort of, people are like, okay, I can print this, but I don't have the ability to scan it. So you'll get it when I come back from my leave. Or so you can see why there's this, you know, it makes a lot more sense to be able to just attach this signature without going through it. There's also, I mean, look, I'm a cynic, but I think there's also the environmental component. Just for example, you know, I'm sitting in Hillcrest. We do a lot of work with particular estates here, and I had to print documents the other day, and it's about a 50-page sale agreement with everything attached. So, you know, to print 50 pages, then sign it and send it back, there's an environmental component to it. And I think people do feel quite good about themselves when they can, you know, get around that. So it's not only more efficient, but it's also environmentally friendly to be able to utilize electronic signatures.
Yeah, and I think there might be even a general assumption that it has become okay because of the digital age that's progressed. But in terms of the law, there are obviously still some rules that needs to be followed. But I think there's a perception of people thinking, it's fine. You know, everyone's doing it, I might as well start doing it. So
no, 100%. So it's convenient, and then there is the perception that there's not an issue. And where the perception comes from, so we in South Africa have what's referred to as the Electronic Communications Transaction Act. And that is the act that governs and provides the legal framework in which electronic signatures exist. And one of the founding sort of statements or founding paragraphs of the act is that a signature isn't going to be invalid just by virtue of being an electronic format. So it's really saying, it's setting this groundwork of saying that by virtue of being electronic isn't going to immediately invalidate a contract because it was signed like that. What people don't do is they don't go further and then look at the act where there's a specific provision that says, well, that's all good and well, but there are exceptions where an electronic signature is going to invalidate an act. And again, that's where we get onto today's topic, because once you read the act properly and you look at the exceptions, you then see that there are problems when it comes to a deed of alienation or sale agreement in respect of a movable property.
Well, that actually does lead me to the next question, which is if you can kind of straightforward just give us some info on if there are any property deals where you can't use an electronic signature at all.
Okay, so if you look at Schedule 2 of that act, it's literally the very last page. And on that page, it specifically says that a sale agreement in respect of immovable property cannot be signed electronically. It will be invalid. And the other one that's relevant to today's topic is a lease, so a long-term lease where it exceeds 20 years. So those two, I mean, there's no confusion, there's no debate around it. It's a provision in legislation that isn't in any way ambiguous. It specifically says that these are the contracts that cannot be signed electronically. And it is those two, sale agreements in respect of immovable property and a long-term lease. And we've already said a sale agreement in respect of a movable property isn't just your traditional sale agreement. It's also sale of shares in a property owning entity. It goes beyond. So yeah, and we will look at why there's confusion, but I mean, the legislation is very clear on the topic. And so when Janet actually first asked me about this, I thought, flip, well, the talk can be 3 minutes and we'll be done. But you know, there's more to discuss around it.
Yes, no, absolutely. And I think basically, I'm sure that there are people who aren't following this rule, I'm assuming, because I think even for me, I've been in situations where I've signed contracts and I've questioned, you know, shouldn't I have put this on wet ink? It sounds like it should have been. But then we move on, and because nothing's happened, because there's no case or investigation that's likely to take place. But maybe that can lead to the next point where maybe we can discuss a court case. I think when we prepared, you mentioned that there's a court case where the usage of electronic signatures were addressed. Perhaps you can elaborate a little bit on that example.
Yeah, so we'll go into the case, but just something else to raise, like you said, with the confusion. I mean, our role as conveyancers is we get a sale agreement, and there's a legal obligation on a conveyancer to make sure that all the documents are in order, and you sign a conveyancer's certificate on every document you send into the deeds office. And that conveyancer's certificate is essentially saying that myself, David Campbell, I've checked the documents. I'm satisfied that all is in order and that this transfer can proceed. So when I get a sale agreement, one of the first things I'm looking at is, how is it signed? Am I comfortable that, because remember, the sale agreement is always going to be the founding document. It's the underlying document on which all transfers or transactions are then based. So if that is invalid, the whole deal is invalid. And if problems arise, a lot of these things, it goes ahead, no one makes an issue of it, and there's not a problem. I mean, that's what would happen in 99% of cases. Where the problems are going to happen, or where issues are going to arise, is where one of the parties subsequently says, no, well, the sale agreement was invalid, I want this overturned, or the transfer to be overturned. And that's where the issues arise. So 99.99% of the times, there's never going to be an issue. You have a willing buyer, a willing seller, and the thing proceeds smoothly. It's where there's an issue, and that's why the conveyancers need to check. And we have situations where, say, we're doing a bond and a conveyancer sends us the sale agreement, as they have to, and we check on behalf of the bank to make sure, because the bank needs to know that the underlying security, being the sale agreement on which the transfer is based, is actually valid. And we've said to other conveyancers, this isn't valid. Your sale agreement needs to be redone. And they've argued with us. And we say, well, here's the legislation. Please go and read it. And, we don't hear from them back until we receive a correct sale agreement. So it's widespread, even amongst the legal fraternity, this sort of gray area. With regards to case law, so there is a case that I think a lot of people, when you sort of Google this, you see this case, and it's Borcherds versus Duxbury. So Borcherds versus Duxbury. What was interesting here is that is a single judge sitting in the Eastern Cape High Court who there was a case going on in terms of which the seller had signed a sale agreement using that program called DocuSign. Now, anyone who signs anything electronically, I mean, that's pretty much the leading software. It's very secure. There's no issue. I mean, if you're signing something your financial advisor sends you, or, that's the program you're using, and you can confidently use it knowing that the data that's getting attached to the sale agreement is your signature. And that's what an electronic signature really is. It's data that's being put forth as your signature that you've accepted.
Yes.
So in that case, you had a judge who saw the sale agreement and saw that it had been signed by DocuSign. When making his decision, the judge got it really wrong in that he looked at what is the intention of the parties. The intention of the seller in affixing his signature using DocuSign was to sell the property. The purchaser's intention when he signed was to purchase the property. And so it goes back to your traditional contract law in terms of which you have a valid contract when there's an offer and acceptance by the two parties. So the judge didn't look much further than that. He said, okay, we've got a situation. There's no dispute that the sale agreement was signed by the seller. The seller's not saying he didn't sign it or accept it. The seller's saying he signed using DocuSign. Purchaser's saying, I signed with wet ink. It was my offer and there was an acceptance. Judge said, well, okay, looking at the general framework of the Electronic Communications Transaction Act, electronic signatures are recognized in South Africa. Ipso facto, this is a valid sale agreement, and the judge found in favor that it was a valid agreement and allowed it. The judge didn't actually look at the legislation and see that, okay, well, it's the legislation, yes, allows for electronic signatures, but not in respect of certain contracts. The judge didn't take the next step of looking at what was in Schedule 2 and what forms of contract wouldn't be valid. So we sit in with a thing where there's one case in the Eastern Cape High Court with one judge sitting who found it to be valid. Now, because it was in the Eastern Cape High Court, it's not binding in any other jurisdictions. So in KZN, if you had that case, if you had the same situation, you wouldn't be able to go to a judge and say there's been precedent that's been set. You would say, no, there's no precedent. There is this case, but they got it wrong. Here's why. And the judge would consider that but wouldn't be bound to follow that ruling. Again, if you then went to the Eastern Cape and you had the same case, what you would say is that, okay, well, there is this, but if we've got a matter where there's 3 judges who are presiding, or if we take that on appeal, so the judge has to consider it, the judge finds it, you then automatically appeal it to 3 judges, and the 3 judges would then overrule it. So again, there's this case that's floating around that the underlying contract or legal contract principles are correct. Offer and acceptance, great. It just didn't look at the legislation, and a judge isn't entitled to interpret legislation where it's, you know, so clearly defined. The judge isn't making legislation. The judge is following legislation, and yeah, there's absolutely no question about what the legislation says. So it was just a poor judgment that now exists and floats around. And again, so when people Google, as they do, that's one of the first things they see.
Absolutely. And that's what people are going to base their perceptions on as well.
Exactly, yeah.
I quickly want to address the audience again. So I've seen a few two people raise hands. Remember, we're not going to take mic questions. We're going to take written questions. I've already seen one question come in, which we'll save for the second half of the session. So just keep in mind, if you have any questions, please drop them on the chat. We will address them. All right. So next I want to address lease agreements, especially those that are shorter than 20 years. I'm looking at lease agreements of maybe 1 year, 2 years, 5 years. So the question here is, can you cancel a lease or make a change to it by email? How does that work?
Okay, so that is a very good question in this context. So I think to draw a line under previous discussion, sale agreement in respect of movable property signed in wet ink, there's no debate around it. We know what the legal position is. That's what has to be done. Lease agreements for property that are shorter than 20 years, there is absolutely no issue with those being signed electronically. It falls under, you've got offer and acceptance, provided that the lease is going to be met with all of the correct legalities. You've defined the property, you've defined the parties, you've got your set rental amount. It can be signed electronically. Where an interesting situation that's arisen, and it can arise with any contract, but it happened with a lease, so it's relevant to talk about, is in a case called Spring Forest Trade-in 599 CC versus Wilbury Pty Limited. So what happened there is you had a situation where parties had entered into a valid lease agreement. It was signed wet ink. I mean, it's not really relevant here, but you had a wet ink signed lease agreement. During the course of the lease, you had an interaction between the parties over email. And, the one party wanted to cancel the lease, so essentially sent an email saying, can we cancel the lease? Other party responded and said yes. Now, there was then a dispute as to whether that constituted a valid cancellation of a lease agreement. So if we look at your standard lease agreement, it contains a clause that says no variations, cancellations, blah, 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 will be valid unless reduced to writing and signed by both of the parties. So any good sale agreement is going to have that clause that's put into it. And that prevents the people from entering into verbal agreements. It gives certainty for everyone. Where this now brings in a new element of uncertainty is that, okay, we know if we are interacting over email, that is in writing. So I send Courtney an email and I say, Courtney, are you prepared to cancel the lease? I've now put it forward in writing. At the bottom of that email, it says, kind regards, David Campbell. Courtney responds to that and says, yes, I have no issue with cancelling the lease. Kind regards, Courtney McKenna. In this situation in the case, the judge said that amounts to a valid cancellation of the sale agreement. The signature at the bottom of your email is actually an electronic signature for the purpose of the Electronic Communications and Transactions Act. So you had met the requirements. It was in writing and signed by both of the parties, and there was clearly an agreement that had been reached. So the minute that the second email was sent, that lease had been validly cancelled, even though one of the parties subsequently tried to dispute it. And the same thing goes, the fact that it's over email is somewhat irrelevant. It can be over WhatsApp, where you're saying, yeah, I'm not happy with this, late at night, had a couple of beers, not happy with this, I want to cancel, from David. Courtney responds and says, okay, David, I'm tired of dealing with you. I don't want a message at 11 at night. Happy to accept your cancellation. Kind regards, Courtney. That has been signed. The placing of the name at the bottom of that constitutes a signature. And therefore, it's incredibly important where you have a contract that's not a sale agreement in respect of immovable property that allows for electronic communications and allows for electronic signatures, to make sure that you are being careful with the correspondence that you're sending backwards and forwards.
Absolutely.
Yeah.
All right. And what's the best way to make sure emails or electronic signatures in this case are taken seriously in agreements? Because I think there's still, even when you started talking, my immediate perception was, oh, well, emails aren't, formal. Well, technically they are.
Yeah.
The to me is notable. So I think, yeah, the question is, what is the best way to make sure that your emails are actually taken seriously before it even gets to a point where it's an issue?
Look, I think the most important thing is you're going back to the drafting of contracts. So remember, you've got legislation on the one hand, and then you've got the provisions of the contract on the other. Now, in terms of a contract, you can't, go contrary to law. So you can't have a clause in a sale agreement for immovable property that says electronic signatures are acceptable, because you've got legislation that specifically says it isn't. But where there's no legislation, such as with a lease agreement, so you've got a situation where a lease agreement less than 20 years is now acceptable to have a electronic signature, in that there's nothing stopping you from putting in a clause that essentially says that an electronic signature will not be acceptable. So you can contract out of it. You can't take the legislation away and change it and go directly against it because you've included a clause, but you can contract out of it in terms of, in that situation, we would say you have a clause in a lease agreement which essentially says no variation, alteration, or consensual termination may be given effect to by way of electronic data messaging. The minute you've got that, those emails aren't going to be changing anything. You're fine.
Absolutely. All right, and maybe we can just conclude before we get to the questions, because we have quite a few. Let's talk about the future. So what is the signatures in property deals will change soon? Are they going to start allowing it more and more? And how can people in real estate stay ahead of these changes?
Look, it's very much surmising. None of us can tell the future, but I do see that this is going to change. I think, there's no real reason why. And if you look at sort of the articles from people a lot smarter than myself that have been done on electronic signatures, they are actually, or can be, more secure than a traditional wet ink signature. I mean, you just need to look at the legislation, and it distinguishes between a simple electronic signature and an advanced electronic signature. And I mean, there's certain contracts that, and it's not worth sort of going into now, it goes beyond the ambit of the discussion, but there's certain contracts that actually require what's an advanced electronic signature. And in that situation, you as a consumer have actually got your electronic signature, and it's been verified by an external source. So there's certain verification agencies that are appointed under the Act that can verify that that's your signature. And that, I mean, it's an incredibly secure form of signature. So, I don't see a change. I don't see it changing right now. I think that there is still place for a traditional wet ink signature. And I think if you look at the nature of the contracts that are excluded, it's immovable property, it's your long-term leases, again, more than 20 years, it constitutes immovable property anyway, and it's wills, and then bills of exchange, which we're not really signing checks but I mean, your will is also, it shows you that it's lumping together wills and contracts of sale in respect of immovable property. And I think we know that in general society, those two documents, in general speak, your purchase of immovable property is probably going to be the biggest asset you ever purchase. In most people's lives. And again, your will is an unbelievably important document to your average consumer. So it's really, at this stage, you can only sort of look at what the legislation is and interpret it as saying, well, these contracts really stand above your standard day-to-day transactions that you're entering into, and therefore we're going to place special importance, and we actually want that wet ink signature. I don't think, like I said, practically going forward, it's sure to change. I mean, it's almost certain. And it's just a matter of amending Schedule 2 to do away with those contracts, and maybe it'll impose other obligations. I'm sure that if they do, they'll say it has to be this advanced electronic signature and all of that. But again, you know, banks are now getting clients in our office to come in and you sign electronically for your bond documents. So, but you still have to sign in front of a conveyancer or an attorney. So, you know, they're saying, yes, there is grounds for this, but they're imposing obligations. So I just think that there is going to be a shift, but it'll be interesting to see what form that takes. And it will have to only be done once everyone's very comfortable with these electronic signatures.
Absolutely. And consider the fact that we are still in a third world country where not a lot of people have technology and equipment to, you know, do the electronic signature thing. So it might still be a while, but I think with technology growing faster, they say that the last 10 years, technology growth is going to be as short as 3 years now. So it's interesting to see how things might change.
I definitely think so. Remember, I mean, our property industry and the way it's regulated, we impose so many checks and balances that if you purchase a property overseas, you really don't see. So when we are actually handling these transactions, we're putting a lot of emphasis on protecting consumers, and I think it's a very good thing. So this is just should be seen as another element of that.
Absolutely. Okay, Dave, we can maybe start with the questions. I'm going to read them one by one. If there is a question that's not relevant to our topic, you could just say we're going to skip that one for now. If the question is a repeat, obviously you'll know better than I do. You're the expert here. But if there's a repeat, you can just say the question's already been addressed. And also to the audience, if Dave does address your question, even though I'm reading someone else's, just please take notes so that we can save time and make sure we get to everyone. Okay, so I'm going to start with Nomusa, who's asking, David, is it possible to tell us the act that talks about the conveyances certificate legislation?
Okay, so there you would be looking at the Deeds Registries Act, which is really where what deals with documents being signed off by conveyancers. It's looking at your, so remember, when you're talking about a conveyancer's signature and the conveyancer's certificate, that is what we attach to a power of attorney to pass transfer and a deed of transfer, and it's essentially the signature by the conveyancer that certifies that all is in order with the documents that they're signing off on, because those are what are going to the deeds office. So yeah, it's the Deeds Registries Act.
All right, then we've got, I don't have a name with this one, but someone's asking, are mandatory disclosures and annexures and addendums to the sale agreement also implicated in this?
Yes, so if you look at the legislation relating to your mandatory disclosure form, in terms of the that act, the Property Practitioners Act, it specifically says that your mandatory disclosure form forms an integral part of your sale agreement. So it is a part of the sale agreement. If you then look further, and again, if you 99% of a sale agreements is going to have the non-variation clause that says, you know, any additions, alterations, amendments need to be reduced to writing and signed by the parties. So again, in order for it to be reduced to writing, we know what that is, but signed by the parties, we then bring in the fact that it can't be electronically signed.
Awesome. All right, then we've got a question from Ingrid. If a lease is 10 years with options 5 times 5, does this fall under Act as long-term lease?
Yes, it does. So when you're looking at a long-term lease, you're looking at what is the original period as well as all extended periods. So if all of those periods go over that, it then becomes a long-term lease.
Fantastic. Richard is asking, please tell us the legislation surrounding signatures. Thanks. I assume either Richard might have entered late or unless there is an additional legislation here. So over to you, Dave.
So it's the Electronic Communications and Transactions Act 2002. And again, what you're looking at there, just to stress, I've got it here, and it's strange where the I just want to confirm the exact sections that say you can't rely on signatures for sale agreements. So if you would be looking at it's section 4, which is sphere of application, read with schedule 2, which is literally the very last page of the legislation. So it is the last page, a small section there that refers back to section 4.4. So yeah, you know, not saying that a judge is excused for not seeing that, but it is in a strange place.
All right. Easy to find, at least. go to the last page.
Yeah, go to the very last page, and there's a little square box that has those.
Awesome. Okay, Benny Shepherd is asking, leases shorter than 20 years, what level of electronic signatures are required? Okay, so I think we did have this discussion earlier in the talk was about leases shorter than 20 years. Yeah, you can maybe just quickly address that one again.
Just to quickly address it, and I think where that could be going is, again, in terms of that act, there are certain contracts that require this advanced electronic signature. A lease agreement shorter than 20 years isn't one of those.
All right.
So it's just your standard electronic signature.
Okay, Martin is asking, an OTP signed in ink by the purchaser is scanned and emailed to the seller. The seller signs it with an Adobe signature, typed initials. Is this a valid acceptance?
No, seller has to actually print that document, apply wet ink to it, and scan and return it. That's exactly what happened in that Eastern Cape case. It doesn't matter what program you use in, the minute that you are not applying wet ink to that contract, it's going to be void.
Right. Okay, Ravashni is asking, is WhatsApp communication valid? It has become a norm for WhatsApp chats to share requests and decisions.
It is, but remember, you have to actually sign off on the message with your name. So in that spring trading case, the relevant part of the judgment, it wasn't the email exchange, it was the kind regards David Campbell at the bottom of that email agreement, which is what the signature is. So, I can just send a WhatsApp where I say, again, hi, Courtney. I haven't signed off on that as myself. If I say, hi, Courtney, kind regards David Campbell, or regards David Campbell, or just David Campbell, then I'm attaching my signature to it.
Right. Martin's asking another question, and he's asking, what constitutes as a valid electronic signature in terms of the Act?
Okay, again, it's very broadly defined. It's any data that attaches to anything that purports to be someone's signature. So it's incredibly broad, unless, again, it's going into advanced electronic signatures, which is where you need to have that independent authority having verified it. And I would assume, so something like DocuSign, that would amount to an advanced electronic signature. The signatures they have there would have been verified by the independent body. Where you have Paint, or whatever the programmers people use now, and you draw your signature, look, that is a signature. I'm putting it there. Yes, it's data being conveyed, but it's been conveyed and purported to be my signature that I've accepted. So provided that it's not specifying it needs to be an advanced electronic signature, then that's fine.
Right. John is asking, what methods of electronic signatures is acceptable on contracts, initials and signatures that is typed out, letters versus initials, and signatures created on PDF full versus DocuSign. So I think that kind of
again, it goes into
just,
the same thing. It's any data that purports to be a signature. So it's very broad.
And then he also asks, is everything discussed today valid for rentals and sales? Which I assume, yes, addresses our lease agreements and our property of sale. Yeah. All right, Trevor, I think we did answer this, can WhatsApp or emails be used to get consent from clients to market as per requirements from the PPRA?
See, so it's quite an interesting one. So I think there, if I'm not mistaken, we're talking about mandates.
It seems like it, yeah.
So our specific approach is generally going to be that, ideally you would have a wet ink signature on a mandate only because it's so closely related to the eventual sale of the property that, there's this link between them. But in terms of legislation and a strict interpretation, no, it doesn't. It can be electronically signed. So again, we also always have to look between, and it's like that clause that I've suggested for a lease agreement where you are saying that you don't want electronic signatures. What is best case practice here? So best case practice is, I would want my mandate to be signed with wet ink, but no, legally it does not actually have to be. It's only the sale agreement because that's what the legislation says.
Okay, Ravashni is giving us another interesting one. When an email is sent but not received, where do we stand legally, especially confirming notice to vacate?
Okay, so that does go somewhat beyond the ambit of this. You see, it's up to the other person. So you'd have to go back to the contract, and that's looking at, your essentially your domicile clause and dealing with the service of documents under the email. So if you have a sale agreement where someone's nominated what their domicile is, and they've nominated as an a notice that's been sent via email is deemed to be received within 4 hours of it being sent, again, that is actually, even if the person didn't receive it or didn't read it, service has still been affected. Again, sending stuff via registered post now, how many people are actually getting those? It's still deemed valid. And remember, the important thing there is it's deemed to be valid. It's not that it's deemed to have been received. It's not that it has physically been received. So if you go down to High Court on any day and you sit and you watch the foreclosure applications and banks, obviously instigating litigation, and generally the judge can say, well, look, I'm not comfortable this person received it, even though they're allowed to send it via email. So there's a bit of discretion there, and we would always say get the sheriff to serve if you're dealing with a lease and you want to make sure that the person was validly terminated. There's all of, again, it's good practice versus what does the actual sale contract say. And you don't want to leave yourself in the hands of a judge. So ideally you can prove the service, but if you've met the requirements, then strictly speaking, you've done what you needed to do.
The next one kind of addresses a topic that you and I discussed when we prepared. Martin says, to his point of an OTP signed electronically, he says that what he also does is he takes a picture of his signature, his actual signature. Adobe allows you to insert it into PDF, and it really looks like it's your actual written signature. And by the time you print it, it's very difficult to tell the difference between the written one and the electronic signature one. So what he says is, unless another attorney or bank asks for the original, no one will actually know. So, and I think that addresses what you said. There's going to be no issue until there's an issue.
There's an issue, exactly. So, there's ways around these things. All we can say is this is what the legal situation is. If you are going to be doing something that looks completely valid, it looks like a wet ink signature, I receive it as a conveyancer. I'm not questioning it. I'm not asking for the original. And remember, in terms of sale of property, you don't need the original sale agreement. It's never called for. So you could get away with it. Where there would be a problem is, again, you need witnesses. So let's think about a situation where you've, as the seller, have done that. The purchaser now wants to get out of the deal and it goes to court. Purchaser says, for whatever reason, I've got a feeling you didn't sign this properly. I can see a faint outline where you've stuck the whatever. They just have a feeling. You're giving evidence under oath that it was validly signed, as are your witnesses potentially. So yeah, yes, you can fool the system, and if you're confident to lie, that's not a problem. Well, I mean, it is a problem for you personally, but yeah, you can get away with it like anything.
Yeah. The next one's interesting. They're asking if a contract has a full signature on it with ink, can the initials be digitally done?
No.
Right.
You need to actually make sure that it's actually, done with wet ink throughout.
Okay. Rian is asking, so you can contract out of certain provisions of the ECT Act, but not others?
Yes, correct. It's like any legislation. You can impose additional obligations, or but where legislation says you cannot do something, so it specifically says you cannot sign a contract with an electronic signature. You can't just decide that you're going to put in a clause that says we are going to be allowed to sign. What you can do is where the act is silent. So the act is silent on lease agreements shorter than 20 years, therefore by implication, they are acceptable. You can, in terms of your contract, make them unacceptable. The parties are accepting that. They can't accept, to change the legislation between themselves, but they can accept to impose an additional obligation by saying that it's not going to be valid. Again, it would be, a simplistic answer would be if the act said that all leases must be signed electronically. You can't then vice versa say, well, electronic signatures won't be valid. You must sign with wet ink. So it's,
Right. The next one, Numi is asking, what happens when the purchaser or seller is overseas? The contract is signed electronically, which is valid in that country, and a dispute arises.
We apply in South African law to the sale agreements in question.
Desonia is asking, Dave, please could you repeat the clause on no variance, or perhaps it can be provided in the group chat.
Okay, I'll go through it slowly. I've got it here. So where's my wording for that? If you just give me a second. Okay, so the best way to phrase it would be to have a clause that says no variation, alteration, or consensual termination may be given effect to by way of electronic data messaging.
Sorry, Dave, I quickly had to plug in my computer.
Oh,
All
sure.
right. All right, I think we had a bit of a load shedding glitch on our plugs here. All right,
And that's
so
perfect. Thanks, Dave.
Okay, have you got it?
Yeah, yeah.
right.
Thank you. So we'll go to the next one now. You can go, Colleen. I was just
Okay,
catching
awesome,
up where we were.
100%. Okay, so Ravashni, my apologies, is asking, is a landlord entitled to rental if he fails to sign a lease contract which has been agreed to via either a WhatsApp or email discussion?
No, so remember, in terms of law, a lease agreement, there's nothing that says a lease agreement has to be reduced to writing and signed by both of the parties. That's a specific lease agreement. Remember, when we discuss in lease agreements here, we're talking that you've got a traditional lease agreement that's been reduced to writing and both of the parties have signed it. That's the lease agreement that we're dealing with here. If there's a verbal agreement to lease a property and the lease agreement doesn't exist, yes, the landlord is entitled to enforce it. You can have a verbal lease agreement. There's no issue with that, and it has the same legal consequences, provided that the parties there's a meeting of minds with regards to what are the terms. So what is the period, what is the property, what is the monthly lease or rental amount? And that's why we would always say it'd be foolish not to reduce it to writing, because if you have a verbal agreement where your lease or your rental amount's 5,000 Rand and there's no one else that's witnessed that and it's not reduced to writing, then the landlord's going to find it quite difficult to recover that amount.
Jessamine or Jessamina, sorry if I'm saying your name wrong, is asking, is in this case, when signing a document in person but on a signature pad, which I know the banks do a lot, is this considered an electronic signature or wet ink?
No, that's an electronic signature. Again, so we, like I said, I'm not an overly technological person, so that's why I would define the electronic signature in sort of contrast to a wet ink signature. And a wet ink signature is you've got a pen in hand, it's got ink, and it is being applied to a page.
Right. We do have an off-topic question here, but I'm first going to see if we have more electronic signature questions.
Sorry, I did see something pop up just while you're looking.
Oh, yes, yes.
Someone did mention that DocuSign isn't actually authenticated, which is interesting. I mean, I don't know. I don't use it because, again, I'm working in a system where we need wet ink signatures. But just so you can bear in mind, I was surmising that DocuSign would have official signatures, advanced signatures, but it doesn't. So that's an interesting point.
I think Adobe might be the one who's got the advanced function because it's got a security feature on it as well. So I think it might be.
Okay. But
but
so it's still not relevant for the conversation because it can't be used for a sale agreement whether advanced or not advanced.
Exactly.
But I see Adobe doesn't. So Rian obviously knows what he's talking about. He uses this a lot.
Well,
Thanks,
again,
Rian.
like you said, it comes back to the law anyway.
Yeah.
All right. So Martin says in the old days, a seller could accept an offer by telegram. Is this still the case?
I would be lying if I said, because Martin, if you can send your email address and I'll do some research with some of my other colleagues who have been around for a bit longer than me and know the legalities of a telegram. I don't know how a telegram operates, but again, you would need to actually apply a signature to it. So I mean, it's fax, so you can fax a contract, it comes through the other side, you sign it with wet ink and you fax it back, that's acceptable. I don't honestly know how a telegram works.
Not anymore though. Okay, Janet is, well, this actually comes from one of our own. Jan says, Dave, you spoke about sending email instructions whilst under the influence of alcohol. Surely a signature where alcohol is consumed is not taken seriously. Yeah,
but you need to prove that the person had been drinking. So again, it goes back to, it is valid until the contrary is proven. So that person who sent it would need to show that they were intoxicated and that they weren't in a frame of mind to actually be able to understand or have the offer and acceptance that's required for the existence of a valid sale agreement. So if you're sitting on your own on a Saturday night drinking, well, then you're going to have problems, because how are you going to show that you were so intoxicated that you couldn't understand what you're doing? Okay, it's not the best example, but it is just saying in a fit of rage, I can send off an email or an email or a WhatsApp message asking to cancel a lease, and the other person accepts, and then it is deemed to be cancelled.
I see there's two people who are asking again about initials, and I think as it was answered before, when it comes to a sale agreement, it has to be wet ink. That those can't be done on.
And I saw someone said there you don't need witnesses. That's correct. But each page of the sale agreement does need to be witnessed by the parties there too. Witnesses themselves aren't. There's no legal requirement for witnesses. In terms of a will, there is, but in terms of a sale agreement, there isn't. There's nothing in legislation. But so if you're two parties to it sign in wet ink and initial all the way through, and your witnesses for whatever reason apply a electronic signature, it's not going to invalidate it because you didn't need the witnesses in the first place.
Right. I think if we can be here all day, I think you're going to get a lot of questions, but we do need to start concluding today's session. I want to make it clear to everyone who's attended, we will be sending a recording to you as well if you want to go back to the discussion and just review what was said and what questions were asked and answered. But we do have to conclude our session at this point. Dave, I really appreciate your time. Thank you so much for the informative information and also paying attention to each of these questions and giving a valid answer for all of them. I've learned something as well, especially as someone who's not specifically in the industry, but I do obviously have had the experience with lease agreements. And whenever I do get to the purchasing process, it's good for me to know this as well. So for me as a bystander, for sure valuable as well.
Yeah, perfect. Well, again, thank you very much for having me. There obviously are a lot of questions around this, and if anyone has any that weren't touched on or that want to bounce around any sort of ideas, by all means, I'm very happy for people to contact me. I think whenever I've done these sort of talks, I've had people contact me afterwards, and it's absolutely no issue. I mean, I find it interesting, and it's part of what we do because it makes our job easier when agents are informed. So that's why we do these things, and that's why we're always very happy to interact. And what I'm saying, I would never say is definitive, and I would be very happy to bounce ideas off anyone. So yeah, again, thanks very much. Enjoyable morning, and please reach out to me if there is anything.
Fantastic. We will share Dave's details in the email that we send out with the recording, so please be on the lookout for that.
Okay, thank you so much, Dave. Thanks for
Thank you.
Thank you to everyone.
Hope everyone has a good rest of the day.
Thank you. Thank you to our audience. Bye-bye.
Bye.